You are a very private person, and you are thinking about bringing a lawsuit against your careless doctor, but you heard that if you go ahead and start a lawsuit in New York against a doctor in a hospital, you're going to have to release all of your medical records. Is this true? Can you go forward with a lawsuit against a careless doctor without disclosing your medical records? Would you like to learn the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You believe your doctor was careless, causing you significant harm and injury. Now, your doctor refuses to accept responsibility for what happened to you. And you're trying to decide what can you do in order to get compensated for all the harms, losses, and damages that you incurred because you believe that the doctor was careless. Now, here's something important. You firmly value your privacy. You don't like telling anybody anything that's going on with you medically. You think it's nobody's business about what happened to you medically. You think nobody should ever be allowed to see your medical records. And under no circumstance do you give anybody, anyone, even your family members, permission to see and review your medical records or to talk to your treating doctors. Okay, that's your right. And now you decide that maybe you have no choice but to bring a lawsuit against your careless doctor. And you are worried, you are anxious, you are very, very concerned about the fact that you have heard that if you go ahead and bring a lawsuit against the careless doctor for medical malpractice, that now your entire medical history, your medical condition is going to be an open book. And that somehow, for some reason, you're going to have to disclose and turn over copies of all of your medical records. Is that true? Will you have to turn over all of your medical records so the defense can actually learn of exactly what problems you had in the past and what problems you have now? The answer is, yes, you will. You will have to turn over those records. You will have to turn over what we call authorization slips. Authorizations are nothing more than permission slips that give the defense lawyers the opportunity to go ahead and send them to your treating doctors and to doctors you have treated with in the past so that they can get copies of your medical records. Now, why won't they simply accept the copies that we provide? I'll tell you why. Because there's something called trust but verify. The defense doesn't really trust what we give them. They don't really know whether we're giving them the full record. So in order to double check and to make sure, they will gladly accept the copies that we give them. However, they are also entitled to get copies directly from your treating doctors. Now, you might be horrified. You might be furious to learn that you have to disclose all of your medical records to these strangers, people you have never met. And you are worried that your medical records are going to get out. You're worried that they'll be posted online somewhere. You are worried that someone's going to disclose this information to your employer or to your family or to somebody whom you don't want to see this information. What do? Can you keep part of it hidden? Can you keep it secret? The answer in New York is no, you can't. Because when you claim that you suffered physical harm and injury as a result of someone else's carelessness, now, how does the defense know whether what you are claiming is really true? How do they know what medical problems you have unless they get copies of your medical records and see for themselves? Unless you give them permission to go ahead and talk to your treating doctors. It's one thing for us to claim in certain documents in the lawsuit that you suffered the following injuries. But the defense looks at that and says, okay, I see that's what they're claiming, but now how do we verify that? How do we make sure that what they're claiming really is true? And the only real way that they can do that is to get copies of your medical records, to go ahead and scour each and every page of every medical record. Only then will they truly understand what problems you had in the past, if any, what your medical history was, as well as what problems you have now. And if they don't have the ability to look at and go through each of your medical records, then guess what? Now they're going to be at a significant disadvantage, and if you throw up roadblocks and direct your attorney not to disclose that information, not to disclose and turn over copies of your medical records, you know what will happen? The defense will go to the judge and say, Judge, we are at a huge disadvantage here. Mr. Oginski and his client are required by law to turn over copies of the medical records, and they are refusing to do so. And they're refusing to give us authorizations or permission slips so that we can go ahead and get copies of the medical records to judge for ourselves. exactly what's going on here. And you know what the judge will do? The judge is going to turn around and say, counselor, if your client intends on going forward with this lawsuit, he has no choice but to turn over these medical records. The concern that your client has about these records being disclosed online is not something that I'm concerned about. It very rarely, if ever, happens. And because of that, and this is the discovery phase of the lawsuit, you and your client are required to turn over these medical records. If you fail to do that, now I will generate an order which basically says that you and your client are precluded, prevented from putting in any evidence at all, if this case goes all the way to trial, about his medical condition. So what does that do? It basically says if you don't turn over these records to the defense, guess what? When your case comes up for trial, you will never be able to get in any evidence at all about the fact that you have any physical injuries. And that will destroy your case. Totally. It will knock your case out of the water. Why? Because if you can't put in any evidence to show what damages you suffered, what injuries you suffered, and how have it supported by testimony from medical doctors who have treated you or medical experts, guess what? Now the jury has nothing to go on and they will not be able to give you anything. Why? Because you, the injured patient, the injured victim, have refused to turn over your medical records. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what really happens in these medical malpractice cases in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.